Often a question that I receive is, instead of a will, would it be better if I had a living trust? And generally the answer is no. Some attorneys have sold this as an estate planning tool that solves all problems, and it really doesn't. A trust can be challenged just like a will, and therefore it doesn't insulate the estate from potential litigation, and you can have the same type of fights over a trust as you can with a will. There are legitimate reasons to enter into trust. If you have assets that would be subject to estate tax planning, you need to make sure your estate planning documents include appropriate trust to minimize those estate taxes. So that's one reason people need a trust. For everybody else, which is most of us, that do not have estate tax planning concerns, the only reason that you would want a living trust as opposed to a will is if you did not want your heirs to have to report to the court an inventory. In other words, it was of great concern to you that your assets will become public knowledge upon your death, because you will have to file an inventory. With a will that's probated, you don't have to inventory the assets of a trust. It keeps things private. For a few people, that is a paramount concern, and that's a good solution. The other is, although Texas has great streamlined probate procedures, not all states do. And Texas probate does not transfer property, real property, land, and real estate in other states, which requires what we call an ancillary probate in another state. So usually we can avoid that by having a trust and transferring that vacation home or that second property or that condo that's in another state into a trust, so it passes outside of probate. Other than that, living trusts are not a good all-purpose solution. They usually cost more than a will. They have ongoing administration costs. You may have to file an annual tax return for them, and so they're not a one-size-fits-all tool.